Judgment in the appeal, the Queen on the application of Bancoult No. 2 and the Secretary of State for Foreign and Commonwealth Affairs.
This is an application of an unusual sort to set aside a previous House of Lords judgment, the reference to which is 2008 UKHL 61. The proceedings are a sequel to the sad story of the removal and resettlement of the 1,000 or so inhabitants of the Chagos Islands, or British Indian Overseas Ocean Territories, BIOT, between 1968 and 1973. The removal was procured by the UK government as part of a process whereby it leased Diego Garcia to the US government as a military base. It was followed in 1971 by an ordinance prohibiting any return. In 2000, Mr. Bancoult, a former inhabitant, obtained an order quashing this ordinance. The then Home Secretary, Mr. Robin Cook, accepted this and commissioned a feasibility study into resettlement. Part 2B of this study, as published in mid-2002, concluded that the costs of long-term inhabitation of the outer islands would be prohibitive and life there would be precarious. In the light of that and some other factors, a new Secretary of State, Mr. Jack Straw, in 2004, procured the making of the BIOT Constitution Order, the 2004 order, introducing a new prohibition on residence or presence in BIOT. Mr. Bancoult challenged this new order. In the House of Lords, all members took as a starting point the findings of the 2B study. Mr. Bancoult's challenge failed by a majority of 3-2. As it happens, I was, along with Lord Bingham, one of the two dissenters who thought that the challenge ought to have succeeded. That there is inherent jurisdiction to set aside a prior judgment in order to correct injustice is clear. The Pinochet case is a classic example. But the injustice cannot simply consist in a conclusion that the prior judgment was wrong or even unjust. It must arise from unfairness in the procedure leading to the previous judgment, such as a party's failure to disclose relevant material, or from fresh evidence. Further, on the authorities, the threshold for setting aside a prior judgment is high. Whether a significant injustice has probably occurred in the case of non-disclosure of material, or whether there is a powerful probability of significant injustice in the case of fresh evidence. There is a possibility that the egregiousness of the procedural failure and or the difficulty of measuring its consequences may favour a lower threshold. The present application has been considered on that hypothesis also. Whether an alternative remedy exists is also relevant to a court's discretion to set aside a prior judgment. On the 1st of April 2010, the government declared a marine protected area, MPA, around BIOT, leading to a yet further challenge by Mr. Bancoult. This has now also reached the Supreme Court, with permission to appeal being given on one ground and the hearing of an application for permission to appeal being directed on another. During this litigation about the MPA, the Secretary of State disclosed various documents not previously located, which related to the drafting of the 2B study, most notably some which have been called the Rashid documents. It is accepted that pursuant to the Secretary of State's duty of candour in public proceedings, these documents should have been disclosed much earlier in the present proceedings. Mr. Bancoult's present application to set aside the House of Lords 2008 judgment is based on, firstly, these documents, and secondly, 4 alleged heads of new evidence. The Supreme Court dismisses Mr. Bancoult's application, again by a majority of 3-2. Lord Mance gives the majority judgment with which Lord Neuberger agrees. Lord Clark gives a separate judgment concurring with Lord Mance's. Lord Carr gives a dissenting judgment with which Lady Hale agrees in a separate dissent. The reason for the majority's decision are as follows. As to non-disclosure, the essential questions are, 1, whether due disclosure of, in particular, the Rashid documents, would have led to a challenge by Mr. Bancoult's representatives to the 2B study in the original judicial review proceedings which led to the House of Lords judgment. And two, if so, whether it is likely that such a challenge would have resulted in a different outcome to the House of Lords 2008 judgment. Assuming without deciding that the first point is satisfied, the majority concludes on a full review of the 2008 judgment of the House of Lords and of the Rashid and other undisclosed documents that there is no probability, likelihood, prospect, or real possibility that a court would, prior to or in 2008, have seen, or indeed that a court would now see, anything in them which could, would, or should have caused the Secretary of State to doubt the conclusions of the 2B study, or have made it irrational or otherwise unjustifiable for the Secretary of State to act on the 2B study in June 2004 by making the 2004 constitutional order. As to the alleged new evidence, the first head consists essentially of analysis and submissions, which the majority has taken into account. The second and third heads consist of material outside the Secretary of State's knowledge at the relevant times, and neither they nor the fourth head provide any basis for setting aside the 2008 judgment. There is a further factor leading to the same conclusion. In 2014 to 15, a new feasibility study was undertaken. This assumed for the first time that resettlement would be permitted on Diego Garcia itself, and on that assumption, this study concludes that scope exists for supported resettlement of Biot. Even if the threshold for setting aside the House of Lords 2008 judgment had been crossed, circumstances have changed in the light of this new study and or subsequent governmental confirmations that the MPA, the Marine Protected Zone area, does not preclude resettlement. The 2B study has effectively been superseded, and it is now open to any Chagossian to mount a fresh challenge to the failure to abrogate the 2004 order in the light of the new 2014-15 study's findings as an alternative to further lengthy litigation and quite possibly a fresh first instance hearing about the factually superseded 2B study. Lord Kerr and Lady Hale would have set aside the 2008 judgment, taking the view on the facts that although the fresh evidence was not admissible, there was a real possibility that a different outcome would have occurred had the Rashid documents been available at the time of the original hearing, and that the 2014-15 study is irrelevant unless the Secretary of State could demonstrate that it would lead to the same result as setting aside the House of Lords judgment.